Good afternoon, everyone, ladies and gentlemen. It is my pleasure today to host and moderate this event on behalf of Corners about the pitfalls of recognition and enforcement of investment treaty awards. BVI is a major destination for enforcement of judgments and arbitration awards. Here at Corners, we often deal with enforcement matters and also seek interim measures in support of enforcement proceedings. But today we will talk about enforcement of investment treaty awards, which in a way are unique type of awards, because these are awards made against states. I mean, I'm muted. Oh, sorry, is it now good? Can you hear me now? I don't know, like.
Yes, we can hear you, and there's almost no background noise. Tim, if you could mute yourself, maybe that would help also. Thank you.
I was just told, apologies that I'm not, they cannot hear me in the audience, but I'm just waiting now for the confirmation that I'm now being heard.
There should be
I think co-panelists, they can hear me, I understand.
So that should be good.
Okay, I'm very sorry for this sort of a small glitch in the modern times of technology, and I will now continue. So we will talk about investment treaty awards, which are unique in the way that they are awards which are enforceable against states. And we are accustomed to seeing private parties on that end. However, these types of claims are brought by foreign investors against states for the reason that they have been in one or another way unfairly treated by the states. And today we will not talk about the process of bringing these claims, which is unique in its own way, but we will talk about what happens when the investor has obtained such an award. And we will focus on the four major topics. First is available different types of regimes for enforcement of investment treaty awards and issues which investors should consider at the outset before starting the proceedings. The second topic would be about strategies that an investor could adopt after securing an award. The third topic is about what state property is available and what defenses the state can put and what type of property is available for enforcement. And finally, I will wrap up talking about remedies which are available after the award has been secured and use BVI as an example. And we have today three distinguished and knowledgeable panelists who are true leaders in their field and who can answer all your questions today that you may have, which we'll take at the very end of the session. So Sophie Lamb, QC, is a partner at London office of Latham & Watkins. Sophie is in the Legal 500 Hall of Fame, and she is described as one of the preeminent arbitration lawyers in her generation. She's a leader in the investment treaty claims and commercial claims, and routinely is instructed by investors and sovereign states. Her experience spans across a number of industries. This includes automotive, banking, financial services, energy and natural resources. She has represented states and investors in 100 international arbitrations, and usually these are complex and high value cases with figures over 1 billion. Our next speaker is Tim Nelson. Tim Nelson is a partner in the New York office of Skadden Arps. Tim represents clients in front of ICSID, ICC, LCA, SIAC, Hong Kong International Arbitration Center, tribunals formed under the ancestral arbitration rules. He also represents clients in front of the federal and state courts of the United States in relation to arbitration. He has co-authored a book called Take the Witness, Cross-Examination in International Arbitration. He's also a co-editor of the Journal of Enforcement of Arbitration Awards. Tim was selected by Benchmark Litigation as a 2021 Benchmark Litigation Star and was named to Law Dragon's inaugural Global Litigation 500 list in 2021. And the last speaker, but not the least, is Denis Parchajev, who's a senior associate in the Motieka and Ozavich's law firm in Lithuania. Denis is an honorable lecturer at the Queen Mary University and routinely appears in arbitration matters. He also has experience of enforcement proceedings, and his specialty is sports arbitration. Denis is recognized by international rankings such as GAR 100 Who's Who Arbitration. So Denis, while staying with you, I would like to ask you a first question. I mentioned that the first topic is going to be about available regimes for recognition and enforcement of investment treaty awards. Are there several regimes? Are there different types of awards? Why are we talking about several regimes, and how is all that different from enforcement of commercial arbitration awards?
So, ladies and gents, good morning, good afternoon, depending on where you are in the world. Let's talk about choices. Now, we all know that the right to choose is regarded as one of the most important attributes of arbitration. We choose arbitrators, we choose whether and where to hold hearings in arbitration, and so on. But I would say one of the most important choices that we can make is actually the choice of a proper regime, ICSID or non-ICSID arbitration. And this choice actually determines the whole dynamic of the case and quite oftenly the outcome of it. They say bad choices make good stories, but I would say that in investment arbitration, you don't want to have a good story. What you want to do is to make the right choice. And the significance of the choice between ICSID and non-ICSID arbitration cannot be overstated. The differences are actually stark. Let's start with non-ICSID investment arbitration. Now, in many respects, the non-ICSID investment arbitration resembles commercial arbitration, the familiar term. Why is it familiar? Because just like in commercial arbitration, we usually choose arbitration rules such as UNCTRO, LCAA, ICC, and so on. So the procedure happens in a very similar dynamic to that of the commercial arbitration. However, more importantly for our topic, in a non-ICSID arbitration, once the award is rendered, it is actually subject to the enforcement regime of the New York Convention. On the flip side, if we choose ICSID arbitration, here things start to get much more interesting. Now, at its very core, ICSID arbitration procedurally actually also resembles the commercial arbitration. You also have similar rules. However, these rules apply very differently. If I had to make one example here, I would say, have a look at how the challenges of the arbitrators work in ICSID and non-ICSID arbitration. On the face of it, the grounds for the challenge are very similar. However, the same principles tend to be applied very differently in ICSID and non-ICSID arbitration. However, again, more importantly for our today's topic, once the award is rendered in the ICSID arbitration, this is where you see the very stark differences. Why is it so? Because the awards in the ICSID arbitration are not subject to the New York Convention. There is no court scrutiny in the ICSID arbitration. And quite oftenly, it is regarded that the ICSID awards are actually automatically enforced. Today, we will put that theory to the test. But before we do, what I would say is that we can probably agree on two things. First, if you cannot collect the money at the end of arbitration, then the arbitration doesn't make sense. Secondly, in ICSID arbitration, it is actually easier to collect the money. And that is why we say that the choice of forum is a very significant one.
So Denis, like if you're saying that it is easier to collect money in the exit arbitration, why would you ever choose non-exit arbitration?
Well, that's actually a tough question. What I would say is that both in the academic circles and amongst the practitioners, we can find a compromise that at least three things can actually weigh in on the choice in favor of non-exit arbitration. First of all, in a non-exit arbitration, you can get lower fees. That's not necessarily the case, but at least that is the perception, that non-exit arbitration is cheaper. Second thing that is usually quoted by the practitioners and academics is that in the non-exit arbitration, you can get a greater confidentiality. Now, we know that exit has made huge strides towards transparency, which is great news for the trust in the system. But some of the investors, and remember that it is the investor who chooses the forum, they actually value privacy and confidentiality. And so they sometimes choose such rules as the UNCITRAL rules, which, especially in their previous iteration, give more flexibility in terms of confidentiality. The third thing that I think affects the choice between exit and non-exit is that it is often regarded that in a non-exit arbitration, there are more lenient jurisdictional requirements. And so the investors who have a little bit of weaker case, they oftentimes choose non-exit to avoid the so-called double barrel test, because they believe that actually winning a case in a non-exit arbitration is easier. But without delving too much into these things, I'd say we should move on to our esteemed fellow panelists to discuss the meaning and the consequences of the choices of the proper forum.
Thank you very much, Denis. And well, it's all very intriguing about the choice, but I would like to ask Sophie. Sophie, is it true that there is a choice that investors can do when they determine under which regime to proceed?
Well, to an extent, Jane, and it of course depends primarily on corporate structure. So depending on the corporate structure of the investor, they may have available to them a selection of different BITs or a national investment law, or even a contract from which to choose. So that fundamental decision will be a function of their corporate structure, and indeed whether they have a contractual relationship with the state. Within those instruments, there may also be a choice. The instrument may give the investor an election between exit arbitration or a non-exit route. And the non-exit route could be, for example, an arbitration under the UNCITRAL rules, or even an institutional arbitration, such as one under the ICC rules. So it has a limited choice.
Well, but then if we do talk about this choice between exit and non-exit arbitration, what consideration the investor should, take into account when making such choice?
So every case is different, of course, but potential considerations would include, firstly, the wording of the relevant treaty and the wording of the arbitration provision in particular. So in an exit context, it may be that the wording of the BIT is expressed in terms of the state shall consent to exit arbitration. And that has been construed not as a standing offer to arbitrate, but as something that requires special after the event consent. So looking closely at the text of the treaty would be the first consideration. The second is something that Denis has touched on already, which is that there is a jurisdictional limit to exit cases pursuant to Article 25 of the Convention. Exit tribunals have a jurisdiction that is limited to disputes in relation to investments. And while there isn't an exhaustive definition in the treaty of that, an understanding of sorts, has emerged. And for these purposes, it might exclude, for example, disputes over shorter term contracts or trading agreements, or indeed disputes where there isn't actually any activity as such in the host state. So that's also a consideration to have in mind. Thirdly, would the tribunal assume jurisdiction over that particular investor in an ICSID context? There are additional personal jurisdiction requirements under the convention, and the most significant is that generally an investor cannot bring an ICSID claim against its own host state. So if it shares nationality, and possibly even if it's a dual national, it may not be able to satisfy that personal jurisdiction test.
And what about in terms of enforcement? What is the difference between choice of ICSID and non-ICSID?
So in terms of enforcement, I'm sorry, but your volume isn't so high.
In terms of enforcement, if there is any difference between the choice of ICSID and non-ICSID, why would the investor make such?
Thanks. So sort of enforcement considerations, and we'll just touch on these briefly because we're going to develop some of these themes as we go through. But the enforcement of ICSID awards, of course, is regulated by Articles 53 and 54 of the Convention, and those create internationally binding obligations on its signatory states to enforce those awards. So, you know, on the face of it, a considerable advantage and apparently a smooth and straightforward and automatic route to recognition. In a non-ICSID context, in a New York Convention state, enforcement will be governed by that instrument. Obviously, the New York Convention is a hugely successful international treaty that covers almost all of the world. So that, you know, going through that instrument it is certainly a benefit. But it of course contains grounds pursuant to which an award can be challenged, and you know, technically speaking, the ICSID Convention doesn't have those sorts of provisions. So they are different regimes.
Understood. And what about the national law? Does it come into play when making the choice?
Well, primarily the enforcement landscape is influenced by whether it's an ICSID or non-ICSID case. So in a non-ICSID route, it's the New York Convention rather than national law, though to an extent, national law concepts of public policy, for example, might come into play under the New York Convention at the enforcement or challenge stage. So things to look out for, you know, if one had a choice of jurisdictions and a number of assets to pursue, you know, things that you might take into account are, for example, whether those courts are experienced in dealing with investment disputes, whether those courts are known to have a backlog, you know, whether they are expeditious in the way in which they handle cases or not, whether there is a history of those courts taking a very expansive and protectionist view of concepts such as public policy. And there are a number of countries that have fallen, you know, into that pattern over time. Just to give another sort of variation on that, we have, you know, certain concerns at the moment. We're certainly observing carefully how the courts of the European Union are treating intra-EU ICSID awards. And as many will know, effectively the EU has said that intra-EU ISDS clauses are invalid under EU law, and hence courts in member states should refuse to enforce them. But that is a webinar all of its own.
Yeah, that's very true. And what about the seat of arbitration? You mentioned that there is a choice between ICSID and non-ICSID arbitration, but is there similar choice of the seat of arbitration? And how does it generally play, you know, is there a seat concept in the ICSID arbitration?
So the ICSID regime is autonomous. It exists sort of outside of and disconnected from any particular legal jurisdiction. So it doesn't have a legal seat. In a non-ICSID context, there will of course need to be a seat. If there is an investment contract, then that seat may have been designated. Otherwise, it's generally for the tribunal, once constituted, to determine that seat. And of course, it will wish to do so in consultation with the parties. So that opens up strategic choices and opportunities for both parties to try and influence a component of the legal landscape at that early stage. And so depending on things, jurisdictional concerns, strengths, weaknesses, and so on, either party may wish to try and influence the choice of seat towards a jurisdiction that has a particular history of interpreting consent provisions, in a particular way. For example, I think generally speaking, both parties would want to choose a jurisdiction with some relevant experience, and generally speaking, both parties will wish to avoid the national courts of the other party, so as to avoid that perceived home court protectionist advantage.
And with all this in mind, what kind of tips you can recommend to the parties at the early stages, to make sure that they don't fall into the traps of enforcement, difficulties?
So I think Denis has touched on this already. Obviously, any party considering embarking on a reasonably long term and let's face it, relatively expensive process will want some assurance that it will be able to monetize its outcome if it's successful in the end. And that is a natural commercial and appropriate consideration for any party who has a claim, and frankly, for any party who is considering funding a claim. The involvement of litigation funders has tended to provoke a more sort of prompt and serious early look at things such as the host state's international assets or receivables position, its credit history, rates at which its debt trades in the international market. So really, looking down the road as to what the monetization options might be. But the reality is a comprehensive due diligence process is expensive, it's time consuming, it's not possible to freeze those assets in advance, so they could well have moved and will likely have been restructured in the years between starting a claim or threatening a claim and getting to judgment. So an educated guess based on the sort of past behavior of the state, its credit history, its general sort of political environment is probably the best that any party can go on.
And now, thank you so much, Sophie. That is very insightful and invaluable. But now moving to Tim. Tim, I know you have a lot of experience in this field, and I wanted, on reflection of what Sophie said, maybe you have some anecdotal examples, or can also say what from your experience went well at the outset when investor did something, or what kind of advice you could give to investors how to think about enforcement ahead of everything. Oh, sorry, you're muted.
I was going to say, thanks, Jane. At the outset of an investment dispute, it's often a very difficult conversation with a client, because the point at which a client has been expropriated is a very low point in the client's business affairs. And so you have to make clear at the outset that they might be in for a long fight. The most important thing strategically is to know your opponent. I would say that every potential opponent, just picking out some large countries at relative random, if I said like Indonesia, China, Russia, Canada, every one of those has different dynamics. And my strategy, not that I would necessarily be adverse to those countries, but in the abstract, I would say the strategy against those countries or big countries or small countries will have to be tailored to that opponent. The most important thing is to have information about the opponent, its likely operations and assets, the likely size of your claim, and the possibility of either getting in front of them and settling the claim or finding assets in a place where that state does business, and getting a realistic assessment of all of those things. Information is the most important thing. It is never too early to have some sort of intelligence or some sort of investigation going on to educate you and the client about your opponent. And I would also say at the very beginning of the case, for client relations purposes and for good discharge of your responsibilities as counsel, make sure that the client feels and that you feel that they have exhausted every means of non-litigious resolution. That is, every kind of negotiation that can be had because once the case goes into the investor state arbitration bucket, as it were, it often gets sent to a part of the government that will be under political pressure not to settle the case and might not even have an interest in settling the case within the bureaucracy. And you're in for the long haul. Now, for the long haul, just one thing I pick up that you and Sophie were talking about, on the choice of seat, you need to make an informed decision about the choice of seat. In practical terms, it's a 7 to 10 year bet in many cases, the choice of seat. So if you're outside the ICSID convention and having to say, and this goes to a point Denis was making as well, assuming there is post-award litigation to set aside an award, assuming I win, assuming the other side sues in the courts of the place of arbitration to try to get the award set aside, that might happen in 5 to 7 years. So you're really saying, say that the seat is New York, you know, you're not asking what a judge in the Southern District of New York, which is the Manhattan Federal Court, would do today. You're asking what the judges in 5 years' time would do, and what the Second Circuit, which is the first level of appeal, would do in 6 years' time. And that's, I'm not just saying that for sport. If you take one critical example, there was a claim by a company called Acmea, a Netherlands company, against Slovakia. And it's quite a notorious case in investor state circles. And Sophie alluded to it. That case began, I think, let's say 12 years ago, and everyone thought in that case that the courts of Germany would be fantastic, that Germany would be a fantastic seat. And I doubt whether many people would disagree if they were sitting around in the year 2007, 2008. The courts of Frankfurt, great. What was not to be predicted was that once the award came down and 10 years later, the courts of Frankfurt would refer the issue up of whether an intra-EU award was enforceable within Europe to the Court of Justice of the European Union in Luxembourg, which came with the notorious Acmea decision of a few years ago, saying that an intra-EU agreement to arbitrate was not compatible with EU law. At least that's the way a lot of people interpret that decision. With the result that the enforceability of the Acmea award is in doubt. That's a tough thing to have to predict. And there have been other examples of, you know, long-term bets on a seat that didn't turn out so well. And you have to explain to a client that on that particular point, choice of seat, you know, you are not equipped with clairvoyance enough to know what will happen in 5 to 10 years' time, even in the best circumstances. So a lot of the stuff at the beginning of the case, strategically and professionally, is managing expectations, making the requisite disclosures, and making the most of the information available to you at the time.
Yeah,
Jane?
that sounds like a very difficult task. And
Yeah.
in terms of like a more simple probably task, what about the amount that you should be claiming at the outset? Is it something that the investor should consider early on? And what about the type of relief the investor should consider? Is any type of relief would be enforceable, or is there some like limitation on this?
It's important to understand the legal tests and what the treaties say. Treaties generally speak in cases of expropriation of the investor being paid fair market value based on the value of the property at the time of the taking. We can have a debate around that, but basically that's the starting point. In the event of a different kind of treaty breach, you're generally compensating the actual monetary loss. So in most cases, the treaty claim concerns a money claim. Just to deal with the non-monetary point first. It is often hoped by investors that they can get the investment restored to them. And sometimes if you are, this is outside investor treaty law, but if you have a contract with the relevant state entity or with the government, you may have the remedy of restitution or specific performance. Within treaty jurisprudence, I'm not aware of many, if any, cases where the tribunal said give it back in a way that was, give the investment back in a way that was meaningful and enforceable. Investors in this situation generally look to monetary relief. In fact, there's a decision in the Occidental against Ecuador case, an early preliminary decision where a tribunal actually said that where there's a state oil concession, the literature does not contemplate that the tribunal would restore title to the state oil concession, that the remedy is generally thought of in terms of money. In terms of money, look, I don't know about Denis or Sophie. I have clients who, if we're on a Zoom call, they will be doing other things and their microphone will be on mute until you talk about the money. I have clients who are only interested in how much money is involved. And so, and in fact, I'd like to meet the client that is not interested in that issue. Well, maybe I wouldn't want to meet that person, but it's always going to be a prime question. You need to have a clear vision of what the claim will be. It is usual, frankly, in a request for arbitration to put your highest and best valuation forward without giving a lot of elaboration around that. Often that's the right number. I'm just saying you know, not many litigators begin with a small number and work up, right? And that is a process that requires expert input and a lot of client input. And I think the real practical part of your question is, if you have a feeling at the beginning of the case that your damages claim might not be enormous, it is very important that everyone involved in the decisions around the case understand that to begin with, because again, you can have a lot of disappointed expectations in this field on the claimant side if you get that wrong. And it also informs enforcement, because while you might think enforcement of a $10 million award is easier on one level than enforcement of a $10 billion award, it's not always as simple as that, and sometimes the leverage that you get out of a big award is more significant in terms of being able to force a settlement, so and not have to go through enforcement. So that needs to be part of the conversation at the beginning of the case.
Thank you very much. So Denis, back to you. So now we have this, imagine we went all through the process of years and years, and finally we have the award. So can we now go on vacation and just relax?
Not quite. The answer is not quite. So imagine a situation where, as you said, the client went through all the processes that were mentioned by Sophie and Tim. They considered everything. They've retained excellent lawyers and they won the case. And now they have this award. Usually this is the point where the client starts opening the champagne, celebrating. But we must not forget that there's still a huge risk that the client will not be able to collect at least part of the money under that award. Oh, Tim, if you could mute yourself. Sorry for the just small background noise. So what I was saying is that there is always a risk that you will not be able to collect under the award. And yes, we will learn today that some of the states comply with the awards voluntarily. But there are also situations where the state doesn't. And what do you do if the state doesn't pay? Well, here again, we are back to our choice of the exit and non-exit arbitration. In a non-exit arbitration, we're coming back to our familiar turf. We're coming back to the New York Convention because the enforcement and recognition in the non-exit arbitration happens under the aegis of the New York Convention. And as we all probably know very well, New York Convention and its Article 5 offers 7 grounds on which national courts they don't have to, but they can refuse recognition and enforcement. Most notoriously, there's the ground called public policy. Now, this ground has been described as the unruly horse or the unpredictable ground just because no one can say what the public policy really is. A lot of things can fall within the scope of the public policy, and this becomes all more important in the investment arbitration. Do not forget that in investment arbitration, you have a situation where private individuals, the arbitrators, are assessing actions of a sovereign, of a state. And so the state will always be tempted to say that whatever the state does in the exercise of the governmental functions is public policy. And so no arbitrator should be allowed to judge them. So the enforcement under the New York Convention can become problematic, but it also can go smoothly. On the flip side, if you go to exit arbitration, there is no court scrutiny. So how does it work? Well, Article 54 of the Exit Convention actually places an obligation on the member states to, quote unquote, recognize an award rendered pursuant to this convention as binding and enforce the pecuniary obligations imposed by that award within its territory, as if it were a final judgment of a court of that state. So this provision automatically transforms the exit award into a final local judgment. And this provision was, at the time of the drafting, it was regarded as this bold innovation, but it also must be read in conjunction with Article 53 of the Exit Convention, which says that an exit award shall be binding on the parties and shall not be subject to any appeal or any other remedy except those provided for in the convention. Each party shall abide by and comply with the terms of the award except to the extent that the enforcement shall have been stayed pursuant to the relevant provisions of the convention. And so these two provisions, Article 53 and Article 54 of the Exit Convention, they, in my opinion, aim to achieve 3 goals. First of all, they aim to create this exclusive and self-sufficient exit regime, which does not need any court intervention. Secondly, these provisions aim to exclude any court scrutiny at the enforcement. And thirdly, and in very plain terms, what these provisions aim to do is they aim to make sure that the case ends with the rendering of the award, and that in the exit arbitration, once the award is rendered, there should be no further litigation, adjudication, or arbitration. That's, of course, the theory. This is the intention of the drafters of the convention. And I would say it would be very interesting to see if the intention of the drafters actually matches the reality of the recognition and enforcement of the exit awards in the modern domestic court practice. And here is where I pass the floor to my fellow speakers.
Thank you so much, Denis. Well, what is actually the reality? Sophie, what is, in your experience, does it mean that the exit award is automatically enforceable?
Well, let me give you 3 examples of the way in which enforcement is not, in fact, automatic, strictly speaking. So the first relates to Denis's correct characterization of the regime as being one which was intended to exclude scrutiny of the award at the enforcement stage by a national court, or frankly by any other body. Yet we have playing out still an ongoing saga in and before the European Court of Justice as to whether payment by Romania under an intra-EU ICSID award constitutes unlawful state aid under EU law. So that's the Mikula case against Romania. The second way in which I suppose it could be said that the enforcement regime isn't strictly speaking automatic is because all jurisdictions will have some procedure or process around the enforcement stage, whether that's as straightforward as registering the award and the act of registration or a particular certificate, or perhaps more than that, a service requirement, a requirement to effect service through that court's own civil procedure rules. It may implicate service of process overseas, it may implicate diplomatic rules and so on. And the third and the big one for our purposes, of course, is that even after those steps have been taken, it isn't necessarily the end of litigation, because we may well still be in litigation for several years and longer over questions such as whether the state owns a particular asset and whether it enjoys immunity over a particular asset. And I know we're going to talk about that some more.
Also, if there is actually a kind of questionable automatic enforcement of ICSID awards, so, is there really difference between enforcement of ICSID and non-ICSID awards? And if there is difference, what's that about?
So I think, really with ICSID awards, I've given you an extreme example of a hurdle, a significant hurdle at the enforcement stage, which is sort of particular to the EU regime and the controversy, if you will, that has emerged in recent times over the relationship between investor-state arbitration and European law. And many people will be very familiar with that and its political context. Otherwise, I think ICSID enforcement processes tend only to, if you will, fail or encounter difficulties because of execution or immunity related disputes over assets. In the non-ICSID context, there is far greater opportunity for interruption, if I can put it that way. Under the New York Convention, the courts at the seat and at the enforcement stage, depending on issues such as estoppel, may have an opportunity to revisit questions such as jurisdiction, and the courts of the seat may also be asked by a disappointed party to look into the overall process of the arbitration, for example, and may be asked to set aside the award on an allegation that there has been some substantial failing in the way in which the proceeding was conducted and whether due process was observed. So those are really the differences, I suppose, between the two regimes.
It sounds there are still, quite a few obstacles on this way. But what does the empirical data say? Do the states comply voluntarily with their awards? And is there a difference how the states comply in ICSID and non-ICSID arbitration?
So look, there is some empirical data. I'm not sure the data set is really substantial enough to be able to draw meaningful conclusions. And I think for those who are active in this field, and particularly for those who do work for investors and states, one tends to get to draw the very strong impression that the question whether or not a state voluntarily complies with an award is particular to that state, and it's particular to its to macroeconomic considerations. It's particular to the political landscape at the time, and of course to its economic situation, how it wishes to position itself for international investment and foreign investment. So it's very hard, I think, to draw a meaningful conclusion from some of the surveys and statistical information that is available. It is said that perhaps half of ICSID awards have been complied with voluntarily. That may be true, but there have been sort of political situations in the past that have perhaps prompted certain states to make voluntary payments, and those considerations no longer apply. So, for example, when certain countries were in their accession stage to the European Union it seems that they paid their awards voluntarily. Query whether they would take that step now.
Well, sounds like there is, not an easy way. If the investor is faced with all these difficulties, are there any alternative strategies, or generally kind of, what strategies, enforcement strategies would you recommend? Because I remember Tim said that, it is a good idea before commencing arbitration proceedings to consider all the kind of non-litigious options. So what would you recommend for investor as an enforcement strategy? Would that include negotiations or anything else?
Of course, and Tim was absolutely right about that. And one of the benefits of opening that dialogue at the beginning, even if it's not successful, is that potentially that dialogue can remain open throughout the dispute and be available again at the enforcement stage. And we do know anecdotally that some awards are settled by negotiation after an award. Some cases are settled after a hearing before an award. There are other opportunities to monetize awards. For example, there is a secondary market for sovereign debt. We all know that. There may not be the most attractive terms, depending on the particular circumstances in which that debt is traded in the moment, but that's certainly also an opportunity. So yes, there are examples other than litigation for several more years about immunity and so on.
And Tim, now going back to you, in your experience, how enforcement of fixed awards is automatic, and do the states tend to comply? Because I know Washington is, of course, big place for those type of disputes about investment treaty awards.
Thank you. Look, let me just preface it. I don't know. I can't pretend to know. I'm not an international relations expert as to why states choose to pay or not pay awards. And there's been instances, like Argentina is a great example in its sovereign debt, where people assumed that that country would remain in default for decades, and there was a change of government and they settle out. So you just never know with sovereigns. Recalcitrants turn good and good citizens turn bad. Our job is to provide the legal framework. Now, can I just, to your question about Washington, I want to draw a distinction between two things that often get fused together in people's minds. Recognition of an award is legally the first step. Enforcement is another step. Okay, so recognition means that a court says, here is an arbitral award, it is now recognized and it becomes a judgment, right? So a lot of our litigation is about getting a United States court, for reasons I'll explain, it's usually in Washington, DC, to convert a piece of paper, an arbitral award, into a judgment of the United States federal courts. A US district court money judgment is an extremely powerful thing, because once you have it, you're in the enforcement stage. Award enforcement is really judgment enforcement in US litigation. When you have a judgment, you can do a number of things. You can levy execution on bank accounts. You can levy execution on shares or other items of property. You can go and attach real estate, assuming it's not sovereign immune, which I'll get to. And also, very powerfully, a United States judge will give broad post-judgment discovery, including of assets outside the United States. So having a US judgment is in many investors' minds the gold standard. Now, how do you get there? How do you recognize the award such that you can get to judgment? That takes several steps, and it's not as automatic as you might think. As a result of some US appellate case decisions, it's been held that you need to serve the petition for recognition and enforcement on the sovereign state, which can take several months. It won't be a surprise that some states don't immediately acknowledge that they've been served with process and take advantage of extended periods that are often afforded to states for responding to a petition to recognize and enforce an award. That litigation almost always nowadays needs to be in the United States District Court for the District of Columbia, which has the ability, it's the venue for when you have a claim against a foreign state. Unless the foreign state, by some circumstances, have assented in advance to a different jurisdiction, which sometimes happens with sovereign bonds. Sometimes you get that in New York, but usually for investor state awards, it's the DC you have to go. You then have to cut through the inertia of the court system. You have to get from filing the petition to judgment. So you have to deal often with technical objections that are made by the respondent state, which I can deal with if we need to. And then you need to get to judgment. Once you get to judgment, a US District Court judgment can be registered in other US District Courts. That is why, for example, Crystal X was able to take a DC judgment to the District of Delaware and thereafter seek attachment of shares held by the government of Venezuela in Citgo. That is how creditors of Indonesia's state-owned entities were able to go to New York and attach bank accounts. Other places you go, the West Coast is a powerful place to go because there's a lot of banking and business done on the West Coast. And sometimes you seek to attach receivables of debtors of the state, and that could take you to different places. I've had cases in, for instance, Seattle and Washington, where that's been an issue. So you go to where you believe the assets are once you have the judgment. It's not an automatic process of simply, therefore, putting the award on the court counter and getting it stamped. You need to go through a process in order to have it recognized and enforced in the United States. And as Denis and Sophie have alluded to already, the process is somewhat different if the award is outside the ICSID Convention and governed by the New York Convention. Somewhat different, not totally different, but somewhat different. And if the award is covered by the ICSID Convention, although the courts of the United States under Article 53 of the ICSID Convention have the obligation to enter an ICSID award as if it were a judgment of a sister state of the United States, the process of doing that can be jammed up by such things as the respondent state bringing a proceeding to annul the award under Article 52 of the ICSID Convention, which might result in a stay of enforcement of the ICSID award pending the outcome of that annulment proceeding. So, don't assume that just because it's an ICSID award or indeed a New York Convention award, you just show up at court and get an instant judgment. There's layers of litigation you've got to go through before you get that judgment. Once you have the judgment, at least in my mind, you have a very powerful thing.
So it's very interesting, at the beginning of the discussion or during the discussion, I was almost convinced that, yes, well, it's not that automatic, but I think that it's still easier to enforce the ICSID award. Now, after I heard you, and I remember Denis told to me, well, sometimes actually you can get a smooth enforcement of the New York Convention. So in your opinion, do you think that still you would stick to the opinion of the majority that enforcement of the ICSID award is easier than the enforcement of the non-ICSID award?
A qualified yes. I'd certainly say on paper and in principle, there are fewer obstacles to getting a petition for recognition approved. Once you petition the US courts for recognition of an ICSID award, there are fewer hurdles. However, in practical terms, it's a matter of luck. And just to use two examples, I've referred to Crystal X already. Crystal X has a $1 billion plus award against Venezuela based on an ICSID additional facility award that was rendered about 5 or 6 years ago. Now, that is not an award governed by the ICSID Convention. It's governed by the New York Convention. the seat of that arbitration was Paris, and Crystalex was able, for various reasons, to get the Paris courts to deal pretty summarily with the objections being made by Venezuela to entry of judgment in Paris, and to get the United States District Court to enter judgment in Washington, D.C., and it was first on the scene in Delaware when it came time for enforcing against Venezuela's equity that it holds through shares indirectly held in Citgo. It's actually held by a company called PDV Holding in Delaware. So ironically, for all the stack of people who had ICSID proceedings against Venezuela, it was the party with the non-ICSID award that got in first. And just so that's one example, but another anecdotal example I could use goes the other way. UCOS has a very, very large $50 billion plus award against Russia, in respect of which they've had enforcement proceedings pending in Washington, D.C. for, I think, 4 or 5 years. And the reason that those have not gone further at this stage is that Russia has been appealing, or seeking to set aside, to be technically precise, seeking to set aside the UCOS award in the courts of the Netherlands, the District Court of The Hague, the next Court of Appeal, and now the Netherlands Supreme Court. And the pendency of that litigation in the Netherlands has persuaded the US court to stay enforcement of the UCOS award, and the US court has furthermore declined to order that a bond be paid as security for that award. So I think luck plays an enormous role. And if somebody says, well, ICSID is better than New York Convention, I would say percentage-wise, the percentages are a little better, but I think you've got to be very careful not to trade in absolutes, and because there's always an example of a case that went faster, even though it wasn't under the ICSID convention. And
so just to wrap up, I know Sophie mentioned some of the enforcement strategies. Can you add something to that? Anything else which you have seen which worked?
So the grand strategy of enforcement, look, I begin by saying, know your opponent, know where the assets are likely to be. There's 2 extreme contrasts I could use, right? One is the rifle shot to say, I don't know where the assets are, or I don't know what the state's going to do, but I'm just going to go to DC and get a judgment there because diplomatically and politically a US judgment is such a powerful thing that I'll come to the table and settle. That's one strategy. Another is the saturation strategy. You roll out in every jurisdiction you can think of, Luxembourg, Australia, Canada, Mongolia, the United States, Britain, France, Germany, just think of everywhere you go and just flood the zone. And that has a rational basis because you don't know where the assets might be. So you just make it so that you could go anyway. So those are the 2. As should be implied, I'd sort of favor a strategy somewhere in the middle where it's a bit more focused.
Thank you so much. As usual, this is a very kind of, valuable comments because as we know, this is not a territory that we often, not the type of awards that we often see in the jurisdiction. And now going back to Denis. So if for whatever reason, the states do not comply voluntarily with investment treaty awards, is there anything that the investor can do about this?
So here, I need to go back to what Sophie said. And I think that, we can all agree that states can have persuasive arguments or at least relatable policy reasons not to comply with certain awards. And I want to talk about ICSID here. And, so how can a state resist the award given the uncompromising nature of Articles 53 and 54 of the Convention, which say that, look, you don't have a choice. You have to recognize and enforce. So where is this resistance coming from? And here is where we need to go to a very important distinction, which was mentioned by Tim, and that is the distinction between recognition and enforcement, or the recognition, enforcement, and execution of the award. Now, there are a few schools of thought on this. Some commentators say that this distinction between the recognition, enforcement, and execution is nothing more than, quote unquote, the unfortunate feature of the language of Article 54 in the English version. And these commentators say that there's no such distinction in the other two official languages, being the Spanish and French language of the ICSID Convention. However, the three main views on this distinction are, there are some commentators who say that the states must both recognize and enforce the award, meaning that they have to pay the award, and that they don't have any means of resistance. But that is not really a sustainable position to take. The other two schools of thought, they either separate between recognition and enforcement, saying that each state must recognize, but they don't have to necessarily enforce the award, meaning they don't have to pay the money. Or there are also commentators who say as per Article 54, the states have to recognize and enforce, but they don't necessarily have to execute the award, which means, and here we have to go to Article 55 to see what that means exactly. And the Article 55 of the Convention here says that nothing in the Article 54 shall be construed as derogating from the law in force in any contracting state relating to the immunity of that state or any foreign state from execution. So essentially what Article 55 says, that there's an additional step to collecting the money. The first step being that you have to recognize and enforce your award, but then there's a separate official step where you have to actually either locate and attach the assets, or you have to locate the assets of the state, attach them, and then prove that those assets are not covered by the sovereign immunity. And in this context, Article 55, which allows for this sovereign immunity defense, it has been the subject of varying degrees of concern, and it has been labeled as this loophole in the automatic enforcement mechanism of the ICSID Convention, or it's even been labeled as the Achilles heel of the convention. And of course, this is all theory that any state can invoke sovereign immunity. But I would be really interested in seeing how this sovereign immunity defense actually works in practice. And this is, I think, where we can turn to our esteemed fellow panelists to talk more about how Article 55 and 54 work in practice.
Thank you so much, Denis. So Tim, I am a bit confused by what Denis just now said, because I thought that if the state, signs the BAT or is a party to the ICSID Convention, they kind of say that they are going to be available for litigation. Does it mean that enforcement is different from that process? Is it completely separate? Can you just a little bit unpack what does it mean? And in that context, if this is a separate process, what considerations should the investors take into account at that stage?
Okay, so again, recognition, enforcement, very different things. There is a school of thought, and my clients hold it, so full disclosure, I'm invested in this position professionally, that if a state agrees to the ICSID Convention or the New York Convention, it has waived objection to having a suit brought against it for recognition of the award and entry thereupon as a judgment. What the ICSID Convention's preservation of sovereign immunity probably means is that once you get to execution, that the normal rules of sovereign immunity in a judgment execution context that would apply in the United States have not been waived. By which I mean, and by the way, most of the law on this issue was generously given to us by the country of Argentina during the sovereign default. So there's a lot of examples of what can and can't be got to in execution and what is and isn't immune from execution. In the United States, and I don't think this is that different from other countries, you can enforce, that is, execute a judgment and send the marshals in to seize property of that state that is being, quote, used for commercial activities. Which means that if you have a bank account being used for commercial activities in New York, it is liable to being attached by award or judgment, by judgment creditors. It means that if you own shares in a petroleum enterprise, as did Venezuela, those shares are liable to being attached. But there are other assets that either are not being used for commercial activities. For instance, if I have an IMF debt as a state, and I have an account that is used to resolve IMF debt, that's not a commercial activity. And there are other assets that will simply be absolutely immune or close to absolutely immune. And the classic examples are diplomatic premises and military assets. So you can't, like I'm just in New York, I'm looking out at New York Harbor, you couldn't attach a French destroyer if it came in parked in the dock. That's not something to do. But there's an interesting and I must say quite amusing case involving the Argentine presidential jet, whose code name was Tango 01. And this jet was impounded in San Francisco for a certain amount of time. And it was the presidential jet. And the argument was, well, it's in the United States, why can't we attach it? And the answer was, well, no, this is the Argentine Air Force owns this jet, therefore it's military property, and under the section, I think it's 1611 of the FSIA, absolutely immune from attachment. And the amusing thing then is that might answer your question as to why the President of the United States flies around on Air Force One, right? That's military property. So there's different grades of property, and you really need your investigators to look for commercial property, and you need to explain to the client that it needs to be actually used for commercial activities in the United States to be available for enforcement.
So you mentioned, of course, here we're talking about enforcement, execution, and we want to get to those assets. So you mentioned, I think, bank accounts that could be available. Yeah. Any other example of those type of assets which could be, as I understand, commercial property and used for commercial? What about if this bank account is used, some of the money is used for sovereign purposes and some are used for commercial purposes? How do you kind of deal with that?
Well, that's an issue that might lead to dispute. There's also a lot of disputes over whether a particular piece of property is owned by the sovereign itself. Argentina at one stage had nationalized Aerolíneas Argentinas, and Chile at one stage had nationalized LAN, and there's case law on whether those separate companies can be equated with the state for enforcement purposes. So there's that. Bank accounts, shares, and debts. Now, by debts, I mean that if somebody owes a bunch of money to a sovereign and they have to pay it through New York, or they're located in New York, you can go and attach that debt, so it's now payable to me, not to them. There's another exotic kind of asset that, again, the Argentina case has taught us about. If you find a corrupt state official who pocketed $10 million and is living in Las Vegas, and this is actually based on a case I can think of, might not be in But if, hypothetically, the person living in a mansion in Las Vegas who stole money from the government, well, that is the government's money in the strict sense because it was purloined, and it can become potentially the creditor's money. So there's lots of lateral thinking that goes into this. The other thing I just mentioned is, if nothing else in the United States, the award creditor or the judgment creditor will get discovery, which might tell it, for instance, there's a BVI company, go down to Tortola, instruct Jane and get her to do it. Or that it's not unusual for discovery to lead you to those places, to the Caymans, to BVI, to Monaco. There are a lot, and often, as you know better than I do probably, that often you often go there because you discover there's shares in some company incorporated in the BVI. You've got to go there. So information can be in and of itself a reward.
Thank you so much. And Sophie, a question for you. I think that recently we have seen some sovereign wealth funds, acting as actually commercial companies and acting commercially. Do you think that could be potentially one of the sources of enforcing such words?
But, it's certainly an interesting area, and in every case it's going to depend on the particular structure of that sovereign wealth fund. Is it a separate legal entity that enjoys complete autonomy, that it can in no way be assimilated with the state, isn't de facto run by the state? So in that situation it will be near to impossible to reach through into its assets. On the other hand, there are some sovereign wealth funds that are not incorporated. They are pools of assets that are very, very closely assimilated with the state. Obviously, there's going to be an inquiry into the purpose of the fund. What's it doing? Is it raising money for essential public purposes, for example? That's going to make it very difficult to attach. And then finally, you have the intervention of central banks. Sometimes those assets are managed by a central bank, and again, it can be very, very, very difficult to displace an immunity in that situation. I just wanted to quickly pick up on Tim's point about information and obtaining information. Even in recent times, we've seen examples of information literally landing in people's laps, and it's things like whistleblowers, the Pandora Papers, and so on. And all of this is just a minefield of potential interesting asset information and many opportunities, I think, Jane, for lawyers in the BVI and offshore jurisdictions to go and explore assets and shares and so on.
Well, we're just waiting for those opportunities. But I've just picked up something you mentioned, that actually whether or not the sovereign fund is available for enforcement depends on the structure, how the assets are structured. So just a general question: what is a state-owned asset?
Yeah, so it's something, it sounds very obvious, something it's an asset that's owned by the state, that's owned by an organ of the state, or that can otherwise be assimilated with the state. When you start looking at a state-owned enterprise, i.e. something with a separate legal personality, the assets of that entity in turn do not belong to the state, unless the state-owned enterprise can be assimilated with the state. Generally, the courts respect and observe corporate separateness, and there are only very, very rare examples of courts sort of piercing the corporate veil. They're typically looking for some sort of fraud fact pattern.
And any other assets maybe you came across which you could add to the list that Tim mentioned, bank accounts, shares, debts, or this in your experience are also the most frequently assets that the investors go after?
Yeah, they are bank accounts, shares, receivables, bond programs, payments, and so on, and of course the occasional private jet. I
see. And yeah, maybe a yacht. And so the presumption, I understand, is really strong against displacing and saying that the assets are actually state assets. And what is the position in the UK on this topic? Is it unique in some ways, or is it similar to the rest of the world? And how do you determine whether some entity is assimilated with the state?
So it's as you say, it's a presumption. It's often a strong presumption. So it will need to be rebutted by really quite cogent and compelling evidence as to the extent of the state's sort of involvement in that entity. Control in and of itself is often insufficient, that the investor actually needs to go further and establish indeed that certain acts perhaps that are performed by the entity are in reality performed by the state, or that they are acts of a sovereign nature. So things that a court might look at are just, as a starting point, separate legal personality, whether the entity was formed by the state, and if so, for what purpose. What does its constitution tell us, if anything, about the extent of state influence and involvement? Does it have operational independence? Does it have its own budget and budgetary independence? What does its own law say about its status? Is it given special autonomous status, for example, under its own law? Whether it's exercising, properly speaking, sovereign functions, or whether, by contrast, it's engaging itself more in sort of commercial activities. And then the degree of control, as I said, in and of itself, not the decisive factor, but obviously, if it has the ability to and does in fact avail itself of the opportunity to involve itself in the operations of the enterprise, then that could be a promising asset.
Thank you very much, Sophie. And just to wrap up, I would like just to say probably a couple of words about the position in the BVI and what actually the investor could do once all of these hoops that we have discussed have been jumped over. And I mean, by this, I mean that there are assets identified, and also those assets are actually available for execution. So in the BVI, as we today spoke, it's actually not that much of a different process. And there is the UK Arbitration International Investment Disputes Act 1966 has been extended to the BVI. So the ICSID awards can be enforced under that act. With regards to the non-ICSID awards, you can enforce them under the Arbitration Act 2013, either as a conventional or non-conventional awards. And of course, that will depend on the nationalities of the parties. And the procedure is easy. Well, we've heard how easy it can be, and on the paper it is easy in a sense that all you need to do is, for the ICSID award, it is the award certified by the Secretary General that needs to be submitted. And for the non-ICSID award, this is original or duly certified award or arbitration agreement. And then, of course, once this is registered, it becomes just a judgment of the High Court, of the BVI High Court. And after that, all the remedies which you would usually seek in support of the enforcement proceedings become available. So Tim rightly said that, for example, Norwich Pharmacal order is available, and you can ask for, if you, of course, satisfied the test, you can ask for disclosure. You can get various types of freezing of injunctions. This can be freezing injunction, mandatory injunction. You can get receivership order, and actually a receivership is quite a powerful tool. And of course, you can attach assets of third parties if they hold assets, if they have a debt which is owned to the state. You could also, of course, try negotiation strategy, as we discussed today. But also, it's actually quite curious probably to know that in the world, I think we only have 5 cases where parties went down the execution road. And these are the cases against Congo, Senegal, Liberia, Kazakhstan. And actually the 5th one was in the BVI, as you may know. And because the process, how it starts in the BVI, is usually without a notice to the other side. In this case, it can be a state or actually some corporate bodies, as it was in our case, which was tried in our jurisdiction. You have actually quite a significant burden of full and frank disclosure. due to full and frank disclosure. So in that particular example, in our jurisdiction, the remedies that were sought were a provisional charging order, injunctive against the shares, injunctive relief against the registered agent, and actually they also sought to appoint receivers. And although the order was granted, I think there has been some time before the return date. So effectively, actually, the order was in place for some time. I think it's almost about a year. But on the return date, that order was discharged, and precisely for the reason because the duty of full and frank disclosure was not adequately covered because of the state immunity and all the concepts surrounding the state emanation of the state concept. So you can see that it is really not easy at all to enforce the investment treaty award. And we are almost coming to the end of our discussion. So if you have any questions, you can post them online. And while you're doing so or thinking to do so, I just want to mention that it's curious that BVI is not party to any BIT, and it's only actually a party to a free trade agreement between European community and overseas countries and territories. But that agreement actually doesn't have any settlement, dispute settlement clause, meaning that if an investor is treated unfairly in the BVI, there is no real mechanism for resolving a dispute. So that is, maybe it will be changed, the situation will change in the future, but the minutes is more like a declaration type of document. And so while I see that the audience is a bit hesitant to ask questions, I just wanted to ask actually a question which is addressed to all panelists, whether you think that given what we will discuss, we will see in the future decline of voluntary compliance by the states with investment treaty awards, and do you think, as you know, Sophie mentioned, maybe there's going to be a spike in execution and chasing assets of the state? Maybe if I could invite Sophie to go first.
Thanks, Jane. I think very, very difficult to make predictions because each state lives according to its own particular political climate. It has its own macroeconomic concerns and objectives, and the decision in any case, whether or not to strike a deal, will involve a very careful balancing of a number of potentially conflicting goals. So I think it's hard to say. I mean, one thing we know for sure, many countries are in an extremely vulnerable economic position, as the result of COVID, but similarly, a lot of opportunity for rebuilding, a lot of opportunity as we embark on a new phase in the energy transition as we try to battle climate change. And so, lots of states are going to have lots of different interests, and all the different voices of government will want to weigh into that discussion as to whether or not, there is a dispute that can be settled.
Yeah, Tim?
Well, if it's all right with you and the sponsors, I'll begin by quoting Tolstoy, or paraphrasing him. He said that, every happy family was happy in the same way, and every unhappy family is unhappy in a different way. And it's the same with states. Every compliant state is compliant in the same way. They pay. And I think Sophie made this point in a different way, but I mean, every non-compliant state has its own particular agenda, its own reasons. There are states, and I think, I would mention like Indonesia and Argentina are classic examples of states that have periods where it doesn't look as if they'd ever pay, and periods where they do pay. There are states like Chile who usually pay. And so I think you're going to be stuck with a few outliers who believe that they never pay. We know who they are. Tolstoy knew where he lived. And but I think the most important thing going forward is this is a serious rule of law issue in the long run, right? The compliance with awards is a challenge for the judges, and it's a challenge for the courts in every one of the states that have signed up to these conventions. There's a reason why, you know, London and New York became big commercial centres. It's because their courts were prepared to make debtors pay their debts. And that's a normal part of the functioning of a healthy world economy. I'm not advocating that we be mean to states that are manifestly incapable of meeting their debts. That's a different debate. But in the general scheme of things, the normal compliance with states with financial obligations, whether the sovereign debt or award debt, is an assumption on which international trade is based. And so I don't want to be in a situation where non-paying is sort of normalized. That's my parting thought.
Denis, what is your perspective from the theoretical, possibly point of view as a lecturer? Where are we going with all this?
So Jane, I think that, you know, in many respects, I totally agree with Sophie and Tim. And I think that you cannot generalize and you can never assume whether the state will or will not pay, because it depends on many social, on many political aspects. And I think the most important aspect is whether that state is actually anticipating an influx of foreign investment. If it is, it will do everything it can to be attractive destination for that investment. If it isn't, then, you know, on the flip side, you can say that there are definitely states that do not view compliance with exit awards as a necessary precondition for the achievement of certain foreign policy goals. But what I think is a very important factor in this discussion is the already mentioned ACMEA case. Why is that? So far, at least this is my strong opinion, that so far the Court of Justice of the European Union has not said that EU courts can disregard exit awards if those awards do not comply with EU law. The CJEU said that about other awards, but it hasn't said so about the exit awards. You can say that something was said in the Mikula case by the General Court, but there was no clear position that you can ignore exit convention. But if the court says that exit awards are actually do not have to be enforced if they contradict EU law, that will send a very strong message even to non-EU members that, you know, the exit convention is not absolute. If it contradicts your constitutional values, you can actually find a way not to enforce those awards. And I think that the way that this whole thing will develop in the EU will affect the voluntary compliance with exit awards.
Thank you so much for time today, Sophie, Tim, and Denis. It was my pleasure to host and moderate this event. It was a very fascinating discussion. And for us in this jurisdiction, I think this is a unique opportunity to hear from such experts as yourself about, you know, various pitfalls on the way to recognize, enforce, and execute the investment treaty awards. And I just wanted to say thank you to the Arcan, which is a sponsor of this session. This is the Russian and CIS Arbitration Network. And also, of course, to the BVI International Arbitration Center for arranging this this event and giving us floor to discuss enforcement and execution of investment treaty awards. Thank you very much.